Ladies and gentlemen, welcome once again to another edition of Labor Talk. Joining me today is Rick Torres, President and Founder of Permanent Solutions Labor Consultants. Also with me, Ahmed Santana, the Vice President of Labor Consulting Division for Permanent Solutions. And I, being your host today, Dan Block, Vice President of Client Relations. Let's go ahead and get things started, gentlemen. You ready?
Yes.
Today's topic, we're actually going to be discussing the particulars concerning deauthorization and decertification, a misconception by employees' parts when they choose or they're wishing to desire the consideration to join a union, how decertification is played both as a union tactic as well as the reality concerning collective bargaining. In addition to that, we also will be discussing those long-term employees who have been part of a collective bargaining agreement for years upon years, and how they must consider pondering the idea of removing the union too. Rick, let's go ahead and get started with you. Let's talk about the general principles of decertification and why this is so hard for many employees to understand when they consider the idea of joining the union in the first place.
Well, Dan, it's important to understand that when there's a union organizing campaign, I mean, first of all, who knows how long the union has been talking to the workers prior to a petition being filed. But they're on an emotional high. They don't want, the union's goal is to put blinders on the employees that they're going after, almost like a horse running down, in a race. All we think about is winning it. You're going to get all these great things. And if you don't want it, listen, don't worry about it. Give us a chance. We'll get in there and we're going to get you a contract. And you're going to have job security. But more than job security, you're going to have respect and dignity and all those other wonderful things. They're on an emotional high. So the last thing they're thinking about and the last thing the union's talking about is, okay, what happens if we don't get you what you want?
Ahmed, let's follow up with you, please. In more layman terms, based on what Rick is saying, again, as a former union organizer, explain the generality of this tactic where the union may in some way mislead the employee to feel, why don't you go ahead and taste it? If you don't like it, you don't have to buy it, when it concerns joining the union and always offering that idea that they could always just get out pretty easy. Is that true?
Absolutely, Dan. And actually, I'm involved in a campaign right now that you get that sentiment, and it happens in two ways. Is the union organizer making that point to these potential members, telling them, because the employees are going to start asking questions to the union organizer, especially after management have brought us into the picture and we are presenting the facts, and then they go back to the organizer and say, how are you going to accomplish all these goals or all these promises that you made to us? And one of the things that the organizer would do real quick is telling them, listen, at the end of the day, if you don't like us, you can get rid of us. That's one of the parts. Also, even sometimes the employee themselves, trying to maybe analyze what's going on. Once they get the facts from both sides, they don't know what to do. They're confused, and they're thinking, well, why not? Let's try it, and then we get rid of it, without understanding how difficult, how hard it is to go to a justification election.
But Dan, Ahmed, don't you? And me and you worked for me when I was an organizing director for the steel workers. But wouldn't you agree that when we were on the union side, that was the last thing we wanted to talk about was decertification. It was all about our message to them is that we have to win, and unless it the company started talking to them about it and educating them about it, that was the last thing that we wanted to talk to them about.
Absolutely, I agree. That's why I was saying that typically happens after management start going through classes and giving the facts, and those employees go back to the organizer and ask questions. How are you going to accomplish all this promise, or how are you going to do this? And that's when the organizer, I guess, in a defense mechanism, and being kind of understanding the how, and I think it's actually when I was an organizer, I think if we get to that point, it was effective, because you're telling people, listen, it's like a warranty. You know, you try us, you don't like it, and actually, even if you go to a store, you want to buy anything, sometimes you look at warranty, and if they tell you, listen, you buy this, you don't like it in a month, 2 months, you can return it.
Yeah.
Oh, I mean, people will be buying things, you know, more.
Well, and I also remember a lot of times when they would say, well, how are you going to get more? You know, I know one of the things that I used to teach my organizers, and me and you've had this discussion before, was to tell them, well, wait a minute, think about it. You know, be rational. After a contract is negotiated, and we knew there was no guarantee that was going to happen either, but after a contract's negotiated, why would you vote for a contract if it gave you less than you have now? Exactly. I mean, come on, have common sense, and that would always get them down. But that's, once again, you know what happens between then and the time if you ever get to that point where you're going to ratify a contract, a lot of things can happen. A lot of things come to play where they will vote for it.
Let's go ahead, gentlemen, and just cover some of the basics real quick pertaining to the rights of employees and in respect to the National Labor Relations Act. As many lay people know, and HR professionals throughout the country, the Act actually offers the rights of employees to self-organize, to form and join a union by a showing of interest of employees to a certain percentage and then request an election. And the same is true for the process of decertification to remove the union. But again, let's go ahead and touch two scenarios here, gents. One is, if they vote in the union and there's not a contract, there's this 1 year bar before they can have another election to consider the idea of voting them out. Give me an idea in your professional experiences, what is going on in that 1 year bar in the eyes or the mentality of the union side?
Are you talking about from the union officials or from the members?
No, really from the union's perspective itself, from the officials, when they're encouraging folks to vote in the union, knowing they have that guarantee of 12 months before anything can happen.
Well, one of the things first, Dan, is that they're going to try to keep them as involved as possible. Having them on the bargaining committee, having them keeping the morale of the employees up. If they're smart. I mean, I've seen organizing or contract negotiations in the first time contract to where the rep didn't even contact the company for 6 months. But with a smart BA, business agent, or someone who's negotiating a contract, if they're smart, they're going to be in control. They're going to try to keep them motivated. They're going to try to keep them, together in the solidarity. But sometimes, and I've seen this happen also, Dan, sometimes they start talking about, well, we have to build our local now, so, we shouldn't have to wait for a contract to start collecting dues. And sometimes they'll even ask the employees who just voted the union in to start voluntarily paying union dues. So it's funny. You see all kinds of things happening within the situation, but keeping them motivated, the eyes on the target. But once again, right away, and I'm sure you'll agree with me, Matt, is that they have to look towards the day when maybe they don't get a contract in that time, and they have to start building the infrastructure of people who are the enforcers of that unit. So if down the road something happens, they're going to want to make sure that they have people to go to keep the employees in line.
And by the way, Rick, and I want to add something. When you were answering the question at the beginning, you mentioned that if they're smart and all that. Also, it depends on the union. I have no doubt that some unions are more political than others and are more interested in organizing employees than getting them a good collective bargaining, a good contract. So some unions are interested in just increasing they're all interested in increasing their membership, but some of them, I can see they're more interested in building membership for political reasons, and they don't get. And we know about those unions. There are unions that we know the jokes about, well, get a real union.
Yeah,
you know that. And so some unions are very even aggressive during collective bargaining. Others are more interested in collective bargaining. Others just in once they get the members, they get the the employees vote yes for the union during the election. They just want to get a contract as soon as possible, and so they use a lot of trying to influence the members to go one way. And one typical, and I know you remember this, is that they would tell the employees, listen, this is the first contract, we're going to do better in the second one.
Yeah, well, yeah, and I agree with you, Matt. I mean, it's not so much that and I've seen a lot of times, well, if they can keep their head over water, get close to what they're getting. The main thing is that they get the, in a closed shop state, they get the dues check off in the union security clause in the contract. And you're absolutely right. I mean, getting the contract is most important because that's when they get guaranteed, the dues being paid. As far as getting them a strong, contract, I mean, yeah, if they can get it, great. But it's not their main concern. Getting the dues check off and the union security clause is the most important thing. And then using those workers and using that win to go ahead and use that momentum to try to organize other workers also.
Gentlemen, it seems that we as practitioners in labor relations really have a sense for the fact that our world has changed and it continues to evolve. For instance, the idea that perhaps formal petitions are not as frequent. However, the concept of perhaps automatic recognition or recognition by the company could be more prevalent if they feel the pressure of a corporate campaign versus attacking the employees. And certainly, if we have expedited elections, or in some case in the future, which may evolve, if we have card check recognition, employees would become unionized without even a vote. Let's go ahead and talk about deauthorization. I think a lot of employees certainly don't understand what that process is. Rick, will you want to start and explain what deauthorization is for us?
Yeah, all deauthorization is, Dan, is that when in a closed shop state, and all that's saying is that you have the right to negotiate a union security clause, and it doesn't mean that the company has to accept that or has to agree to that in contract negotiations. And all that's saying is that we're going to the workers want to take that clause out of the contract, and that's just saying that as a condition of employment that they have to pay dues. And by the way, Dan, in a deauthorization petition, you do not have to wait a certain time. You can file that deauthorization petition at any point in the contract. You don't have to wait. There's not a specific time like in a decertification, so many days prior to the expiration of the contract. Deauthorization can be filed at any time during the term of the contract.
So in a closed state shop where employees, by contract, if they have a union security clause, they are mandated by agreement to be compelled to pay dues.
Yeah.
But again, in a deauthorization, they are not necessarily represented by the union?
No, they're represented by the union, Dan. But is when they're represented by the union and they have a contract and they have a union security clause, and what's that saying is that the workers have collectively come together to say that we want to take that clause out of the contract. And that's what it is. Just all it's saying is that as a condition of employment, we do not have to pay dues. I mean, you don't have to be a member. The union can't compel you to be a member, but with a union security clause, they can compel you to pay dues. And all that's saying is, as a condition of employment, we don't have to pay dues. So it's almost making it like a right to work state.
Absolutely, yeah.
And we've had a chance to talk about before where even though employees may have a legal right to decertify or deauthorize, there's a challenge here, especially if they become a card-holding member of the union. Would you all mind explaining what could be the challenge to the employee being a union member with their requirement or obligation as far as the union rules?
Yeah,
absolutely. And actually, yesterday I was reading the Constitution. This is all based on the Constitution of this particular union. And when they were talking about trials and appeals, it says that one of the violations would be gross disloyalty or conduct on becoming a union member. I mean, I was having actually a meeting with these employees, and the employees were asking me, what does that mean? And I said, I don't know. And that is the point. And then I said, actually, I don't know exactly what it means, but one of the things that I know it means is that if you either desauthorize, file for deauthorization or decertification, that is for sure a violation of that clause in the Constitution. So they're going to get a lot of pressure because they're violating the Constitution, and they're going to get a lot of pressure for the union, period, including the stewards, the people that are inside their particular bargaining unit, and that pressure is enormous. We know it's huge. We know that the union is not going to just sit down and allow any group of employee or either deauthorize it or decertify the union, which is even worse.
Well, wow. Well, hold on one second there, Ahmed. Let me make sure I understand what you're trying to tell me. You have a union member who has joined the union. They have voted in the union. They now have a union contract. They have a legal right by federal law to remove that union. Are you telling me now they could all of a sudden be held in some kind of trial or court to kick out the union?
Well, let me jump in, Dan. First of all, the Act, the National Labor Relations Act, gives members the right to decertify or deauthorize from a union. But it also gives the union the right to uphold its constitution and international and local bylaws. Okay, so but what they do say, and this is where it gets tricky, what the Act, the National Labor Relations Act says, that if someone is in violation of the Constitution by trying to decertify the unit, that they can be brought up on charges, but they can be punished, but they cannot be monetarily punished. They can be punished in other ways. But if you think about it, in a closed shop state, if it's up to expelling them from the membership and they don't pay dues, then it could eventually possibly lead to them losing the job if they don't pay dues. So there's a lot of things that can happen, but once again it gets complicated. It gets complicated when you talk to workers. Now there's one way that workers, just like in the past, I was a strike director, and one of the things that they could do is prior to working on a decertification, prior to it, just like prior to a strike, they could even if in a closed shop state, they could write a letter to the local and to the international and request or demand that they are released from membership. They'll still have to pay dues, but they no longer want to be a member. Okay, and they can do that, go through the decertification or deauthorization process, and not be held up to the rules within the Constitution because they are not members, even though they're paying dues.
Yeah, and I also think, and Rick is right, and I also think that's why, in real life, even more important that the Constitution, it will be the pressure. The subtle pressure, and sometimes not so subtle pressure from other members, from the shop stewards, and from the union rep. That pressure that you don't see it, that pressure that cannot be proved. They may file you a pleas, but that pressure is that's why employees, in my opinion, sometimes, or members, in my opinion, they either withdraw petitions when they file petitions for the authorization. There's so much pressure on them, that they just quit doing it.
Well, absolutely, you're absolutely right. That's a whole other side of the coin. We're talking about the legalities, but on the emotional, on the human side of it, you're right. The amount of pressure, especially in a unit that's important to the local or to the international, the amount of pressure that's going to be extracted on the members that are trying to decertify or deauthorize can be tremendous. The intimidation, we see it all the time in organizing campaigns, or when I was a strike coordinator or a corporate campaign coordinator. It amazes me, even to today, it amazes me how grown men and women rewind until, almost like when they're children, and they have, and the peer pressure just makes them want to run and hide in the corner. It's still, to today, it surprises me how intimidating these people, these union supporters or the union officials can be. And what's even more surprising, I mean, that doesn't surprise me so much, but what really surprises me is how beat down some people can become, and almost like the children again, and they just, well, I don't want to say anything bad about the union. I don't want to talk about it because I don't want pressure, and even to the point of where they get scared. They want to run out of the plant or the hospital, whatever facility, type of facility it is. I mean, the fear and it just amazes me.
Yeah, and actually, I think just to understand this decertification process. I mean, everybody, if you ask anybody, the cardinal sin of a union member is crossing the picket line. But actually, Rick, and I don't know if you agree with me, but the decertification process actually is going to do more damage to a union than crossing the picket line. During the strike, there's more emotions involved. That's why we call it, that's a cardinal sin of a union member. For trying to decertify their own union is even worse because it's more damage for that union.
Well, I don't know if I would say that it's worse, Ahmed, because during a strike, I mean, the whole point of it, and this is why a union has to exert pressure on memberships. They have to have control of their members, because someone crossing the picket line on a strike is almost like a ball of twine unwinding, because once one person crosses the picket line and they get through it, then other people are going to do it also. So I definitely would not say it's worse, but
it's number two.
It's a strike. There's too much involved, too much money involved.
Gentlemen, let me give you a couple scenarios that I would like you to try to address that I think some employees and managers may have based on certain scenarios they may face. One is you have a union member who, whether they've been in the union for a year, for 10 years, for 20, and finally they're realizing, you know what, I don't know what good they're doing for me anymore. I think I want to be union free again. And they go ahead and they either go through a deauthorization process, or they try to initiate a decertification. And lo and behold, they get this phone call from the union saying, we wish to talk to you. We wish to talk to you in a trial among your peers. Explain to us how that process works. Because as a member, I'm sitting here thinking, fine, wow, a trial? I'll get myself an attorney to help represent me.
First of all, they wouldn't call you up and tell you this. You receive a registered letter. Either at home or at work, whatever. You receive a registered letter. It's an official legal process. And it's an internal process also, Dan, is that you're going to be, what the local that sends you, and there's got to be someone who files a complaint against you. But the local that sends you the certified letter demanding that you come to the trial, it's an internal process. The executive board of that local is going to hear you out. You can bring a couple of witnesses who are also members, but there is no outside counsel that you can bring. It's completely an internal process. A couple members you can bring to try to back up your claim or your defense, but that's it. And after that hearing's over, and I've been in many of these type of hearings, as an international official overlooking whether it be on a strike a situation or other situations, and the executive board has complete control. They can listen to the testimony, they can listen to the witness, or they can choose not to. And there's no standard that they have to follow. The only standard they have to follow is protocol, is how they notify you and how they conduct the hearing. But as far as proof, there's none.
And let's offer you another scenario, one that we may have heard just recently with one of our clients. You have a bargaining unit, a group of employees within the operation that is unionized. Their contract has expired, perhaps a month ago, a year ago, 2 years ago. Now the employees are sitting here saying, we have a contract that's expired, we have no existing contract in place. Where do they stand as far as their legal rights to decertify now?
Well, and it also depends on, Dan, if there is a month-to-month extension, there may be a day-to-day extension. Normally that's the case during a strike. And if there's a month-to-month extension, then there's nothing they can do. If there's a day-to-day extension, there's nothing they can do, because the contract is the bar to the certification. So even if it's on a day-to-day basis, they cannot. There's nothing they can do. Only when in my experience, only when the company realizes that they're more than likely going to have to go on strike and that they have to start playing hardball is will they suspend the contract and there is no protection. Okay? So once again, if they're negotiating, more than likely the company's going to extend that contract month to month, day to day. Usually the only time that they get ready to do that in contract negotiations is when, in my experience, is when they're getting ready to go on a strike and they just throw the hatchet down and we're gonna suspend everything and there's no longer a day-to-day or month-to-month extension of the contract and there's no protection, so the company can pretty much has carte blanche of what it wants to do. That's the only time that they can do it. But at that point in time, more than likely you're going out on strike.
Well, I guess again, Rick, and for you too, Ahmed, we spoke about that 1 year bar. I guess I'm referring to the contract bar where, the employees, do they have a window of opportunity to even file a petition to consider the idea of voting for decertification if their employer and the union go ahead and they renew the contract automatically every 3 years?
Dan, no. I mean, because there is no period, there's no gap.
There's no expiration.
There's no expiration.
So as long as there's no expiration, that window of opportunity doesn't exist.
Doesn't exist.
So really, again, we are learning here in layman terms, once you're voted in, you may be in for good.
Well, right. I mean, and there's a lot of contracts that will state, and I've dealt with this a lot of times in the past, that you have to file in whatever period of time. It might be 6 months, it might be 7 months. You have to let us know in a certain amount of time, and it might be 6 months prior to the expiration of the contract that there has to be a request sent that with a desire that we want to renegotiate the contract at the expiration. If that's the case, then they have the same rules and that they would normally have. But if the company does not send that, then the contract just continues. And I mean, it could take many forms. It could take many forms. We could say, well, we may not negotiate one aspect of it, or we may, if we have an annual increase, we'll just continue with that. But unless there's a gap, an expiration in the contract, then that's it.
Well, actually, and now just then, I was going off the record of this local union in New York State. And we were going to the records of the last 20 years, and just to give you an example, in the last 20 years, this particular local union, their members filed 29 decertifications petitions in the last 20 years, and out of those 29, only twice the employees were able to successfully, get rid of the union. In 20 years, only 29, actually 17 of them, they withdraw the petition. So they didn't even have a chance to get to a vote. They did it 12 times, only twice in 20 years they were able to be successful in getting rid of the union. So I think the numbers speak for themselves in that particular local union, and I'm pretty sure it is the case across the country.
It's reflective.
It is a reflection of what happened. That is very, very, very difficult. Yeah, you can do it legally, but it's very, very hard.
As one last closing statement, gentlemen, let's speak about the scenario which seems to be pretty common in today's world, especially in the United States. Employee groups who have been unionized for years, if not decades, and the thought perhaps doesn't even come to mind, well, we could kick them out. So there seems to be an assumption where management becomes immune to the fact of having the union, and now the employees just feel like, you know what, this is just how it is.
Well, Dan, and I tell you what, once again, it goes back to the union. For instance, a lot of times when I was on the other side, and we used to teach locals how to go in and deal with their members and communicate with them. When a local, because a lot of times members say, well, what, you locals never do nothing for me. I don't have any problems. I don't have any issues. So what do I need a union for? I get treated good by management. The first thing the local was saying, and once again, it's all about a certain a certain amount of mind control. Because once again, I'm going to go back to the same thing that I say, no matter what the situation is, organizing campaigns, corporate campaigns, strikes, other types of issues that happen within the workplace, but the union will always, if they're smart, they're going to, once again, they play this mind game constantly because they always have to be relevant. But it's always, well, listen, guess what? We haven't had, and they'll twist that. It's almost like a political campaign. They'll say, listen, we haven't had a grievance in 5 years. So the question is, the question is not, or the answer is not, well, what do I need a union for? It's the situation that the union would twist it to say is, listen, we're so good in protecting you, we prevent the problems and the issues from happening before they get to a point where you got to file a petition. So we're protecting you. The whole point of it is you don't have to file protections because we're always on the job. We're on the job making sure that the company adheres to the contract and the rules and regulations. So we're going to prevent the atmosphere to get to the point to where you have to file a petition because we are staying ahead of the curve. We're making sure that they don't violate your rights. So the proof that the union is effective and the union is relevant and strong is the fact that you don't have grievances.
Absolutely, and the message being, as Rick said, also is then if you get rid of us, then things are going to get worse and they're going to happen.
Yeah.
Ahmed, let's start with you first. In closing, let's first address the audience that already has a union. Those that have a union, their employees are unionized, and the idea potentially comes up where they call you and say, there may be a catalyst here for the potential of a decertification. What advice do you have for management as well as for their employees?
Well, the first thing is this: is prior to a petition being filed and accepted by the National Labor Relations Board, management cannot promote any activity. They cannot promote it. So that's very important to understand that. But if your workers come to you to ask you a factual question on their rights as far as the law, then you have the right to give them that information. Just here's the information, do what you want with it, don't promote it, don't encourage it, but you can give them the information. If it's to be, it's to be, and they're going to go ahead and act on it, but you have to stay out of it. Once a petition is filed, then you can actively, and it's accepted by the board, then you can actively campaign. But prior to that, you have to give you the facts, give you the information, but don't promote it.
And Ahmed, let me go ahead and go to you then. For those non-union employees, which are a great majority of the clientele that you touch base with, they actually may have never experienced anything like this. And now for them to be faced with their uneducated staff who may come to them and say, you know what, I may want to try this, and if I don't like it, I could always remove the union. And so what advice do you have for management who are non-union, who are facing potentially organizing activity, and that organizing tactic as far as telling the employees there's always that chance that you could kick them out?
Well, then, besides, my first advice is to call Permanent Solutions. To be honest with you, or somebody who is who understands this. But then my advice is they need to train the managers to understand how the process of decertification works, so that they can express that to the employees, because the employees need to understand the process, how difficult it is. But if the management doesn't know the process, then the employees are not going to know. Okay, so it's important to talk about the Constitution, which is going to have a clause always about being disloyal to the union, etc., and to understand how difficult it is, even if they can get the information to show the numbers, the real numbers of that particular labor union, local union, on how difficult it has been through years for all the members who try to get rid of the union. So that would be my advice to management.
You're right on it, man. But I will go on to tell you that once again, in whether it be in print or on webinars or on the podcast, I will always go back and say that once again the biggest cause of union organizing campaigns is the breakdown of communications between frontline supervisors and the employers. Biggest cause. So if that's the biggest cause, then you have a problem with communicating with them. Okay, there's already a distrust and a disconnection. So now you have the supervisors going and starting to talk to them about these issues and these facts and you know the National Labor Relations Act. But with that disconnect being there, it's hard to communicate with them. You have to establish quickly, and this is why preventing issues from happening is so important. Maintain the quality of your relationship, because once again you have to create the atmosphere within the work environment that for workers to even want to listen to what you have to say. Remember that the union's been in there, and their whole goal is to put the blinders on you and put the earplugs in you, so you don't see them, you don't hear them, and they are not important. They're not going to pay attention to you. So once again, there's a lot of things you can do afterwards. How effective it's going to be depends on the atmosphere that you can create. So you may have all the facts in the world, and you may have all the numbers and everything down packed, but they may not do you a bit of good because the employees are not listening to you, because they don't trust you, because the union's been in there making you the worst enemy, and so it might be difficult. Once again, the best thing you can do is not wait for your house to start burning down before calling the fire department. Get in there and start doing those day-to-day things that you need to do. In fact, making staying union free part of your corporate DNA. So you never get to that point. Once you get to that point, it's very hard to change the direction of the relationship, and especially if we get into this reduced election process, then expedited election process, then you have 5 to 15 days or whatever it's going to be. I'm telling you, it's going to be very hard to be able to get and communicate with them at all.
Well, gentlemen, I wish to thank both of you for your time and your professional experience and understanding on this subject matter. What a whirlwind of this event has been to be able to share in this roundtable for our audience today on this very specific and worthwhile topic. For many of our employers, many of our clients, the employees, and their employer, they certainly will learn a lot from your input. Again, to our audience, thank you for tuning in. On behalf of Rick Torres, Ahmed Santana, I am Dan Block, all with Permanent Solutions Labor Consultants. We appreciate your time to join us, and please look forward to joining us for future podcasts and webinars by reviewing on our website, PSLabor.com. Thank you and good night.